the Legal Roundtable Viewpoint. In this segment, we're talking about same-sex marriage, as this issue is currently before the United States Supreme Court. And talking about these issues today, we have Professor Herbert Brown. He's an assistant professor of legal analysis and writing, and also teaches constitutional law as well as several other courses at Southern University Law Center. He has conducted extensive scholarly research and has made scholarly presentations and has publications in the area of lesbian, gay, bisexual, and transgender rights. We also have with us Mr. Lloyd Benson. Mr. Benson is a community leader who is the founder and mentor of the David Paul Learning Institute. He's a member of the University of Phoenix faculty and leader of the University of Phoenix Alumni Association, institutional head of Boy Scouts of America, commission member of BREC, and also chief financial officer of World Link of Churches and Ministry. Welcome both of you all to the Legal Roundtable Viewpoint.
Thank you for having us.
Thank you.
Obviously, as you all know, the U.S. Supreme Court is currently addressing this issue of the constitutionality of same-sex marriage, and I want to talk about some of these issues. And I'll start with you, Professor Brown, since you're a constitutional law professor. Do gays have this right to marry under the Constitution?
Well, when we're talking about the Constitution, we're mainly talking about the 14th Amendment. And under the 14th Amendment, they have two bases upon which to state a claim that they have a constitutional right to be recognized as same-sex couples engaged in marriage. The first avenue that they can do so is under Equal Protection Clause, just meaning that if you have two sets of people and you're treating them differently, you have to have a justification for treating them differently. And the other is that there's a fundamental right under the substantive due process clause of the 14th Amendment, just saying that certain rights are so protected by your privacy that the state shouldn't infringe upon those rights unless they have a exceedingly justification for doing so.
And I know that the U.S. Supreme Court has held that marriage is a fundamental right, and I know that they have utilized that analysis in even determining that, you know, you could have interracial marriages in the Loving case. But I guess, as you said, they have to have some significant reason for that. And I mean, are you finding that there is any particular reason? Are they even articulating a particular reason for this classification?
Well, they are articulating plenty of reasons for it, but the courts are saying that these are not legitimate or not significant justifications for denying these persons the right to engage in this behavior, such as marriage.
Right. Now, I know that one of the issues that they're talking about, which I think people are finding a little unusual, is this whole question about whether or not it's really about procreation, and if marriage is really about, you know, the ability to procreate, and if that's the case, since same-sex couples can't, then there is no, you don't have the necessity. What do you think about that, Mr. Benson, about that argument? Is that sufficient?
I don't agree with that. It's not just solely about procreation. I base my principles solely on the Bible. Being a Christian man, I believe the Bible is the Constitution that we have to live by as Christians. So I believe the Bible speaks about marriage, it speaks about family, and the specific needs and what takes place in the family atmosphere. I believe, you know, in order for one person to do their job that they were created to do, then each person has to play their role, being a mother and a father. I believe that the mother plays that nurturing role. As much as I love my daughter, I love my son, I could never take the place of that motherly love. In the opposite, as much as my wife, she has to discipline our children from time to time, she could never take the place of me being a man in their life. So I believe there's more implications, more things that you know, cause the need for a family as traditionally defined as a man and a woman in a marriage.
Okay, you raise a couple of good issues that I want to talk about, and one of those issues is, I know you're talking about the traditional roles, and that has been stated quite a bit, but we know that there has been really quite a deviation from those traditional roles today. I mean, when we're talking about 40–50% of marriages ending in divorce, you know, over 50% of children now born outside of wedlock. Have we lost those traditional roles anyway, whether or not we allow same-sex marriage?
That comes as a result of desensitized. We've been desensitized, I believe, through media, through our social media outlets, even with the shows that are now become the most popular, the things that we once despised, we rush home to get to and watch every evening. Extramarital relationships. Now we find ourselves, now we're rooting for the person that's fell in love with the married man, or we're rooting for that same-sex couple to think. And I think those things came through the result of how we're exposed to information. My mother, my father, my grandparents, they weren't exposed to these things like we're exposed to, and even children in the cartoons that they watch, although they're animated, these shows carry a certain undertone, a message that children are now, they're not even really valuing the role of even men in the house, or you know.
Let me just ask you this, though. You know, you said that your position is primarily rooted in the Bible, and we know that at least as far as the U.S. Supreme Court is concerned, they're not going to really look at that aspect. So do you feel like there are other arguments that outside of religion that supports not allowing same-sex marriage?
I would say, as far as the legal perspective, you know, I wouldn't want to give my opinion on that. I don't think I know enough about the Constitution and those laws, but I would say, in my opinion, I just have to go off of those biblical principles.
Okay. Now, Professor Brown, I have a question for you. Civil unions, that had always been something that had been sort of suggested or offered, you know, to give same-sex couples a lot of the rights that are being missed by not being able to be a married couple. Is that sufficient to allow these civil unions, this civil contract, is that sufficient to comply with this fundamental right to marry, in your opinion?
I don't think that's sufficient to comply with this fundamental right to marry, because once again, the fundamental right is to marriage. And I also think that you create two separate tracks. You create two things that you say are equal, but in the minds of other people, they know it is not equal. So we have another case of separate but equal. So I don't think that civil unions or domestic partnerships are sufficient in the case of when the fundamental right is marriage. The Supreme Court has said in the Loving case, as you mentioned before, that marriage is a fundamental right. So the idea of marriage must be the fundamental right, not this separate thing that we don't know what to define it as, and we don't know what the legal principles are going to be for it. Let's just call it civil unions and domestic partnerships.
I know, and even in California, one of the courts in California said that, you know, just having the union is specifically denying them of that right to marry, and it's there for that very purpose. One of the things that has garnered a lot of attention about this issue is that it seems that it's a generational divide more so than a political or you know, a party issue, that younger people are more likely to support same-sex marriage as opposed to older people, as you indicated, people who grew up in a different time, a different era, seeming to be more against this. And to what do you attribute that being more of a generational issue?
I would say young people or the generation, there is less opportunity for them to, I think it's more of a social identity type of situation. I feel like it's more of a conformity. I think they know idealistically what it should be, but I don't think anyone right now wants to be the antagonist, because there's so many major figures that are supporting this direction. But I really believe that, you know, people, they know, the generation knows, but it's more so of a conformity to what's taking place and what mainstream is doing versus what they know to be true.
Exactly, and it's certainly.
I would like to comment on that.
Yes.
I would take the opposite position. I think that it's not so much conformity. I think it's more so they've realized that it doesn't matter. They've realized that it's their friends, it's their brothers and sisters, it's their cousins, it's their co-workers, and they realize, you were my co-worker before, you were my sister before, you were my brother before. It doesn't matter. So I think it's more so of it's just the extra thing that doesn't matter. It doesn't paint you in a different picture. I don't think there's this conformity thing at all. It's just that it doesn't make a difference in the person that you are at heart.
And I'm glad we've had this discussion. I'm glad we've had two people who really feel strongly about these positions, but that's all we have time for in this segment. And U.S. Supreme Court will be addressing this issue should they get to the substantive issues, because we know there are some procedural issues that may prevent them from even addressing this, but we should get a decision by June of this year. That's all we have time for in this segment of the Legal Roundtable. Viewpoint, stay with us. We've got more of the Legal Roundtable in just a moment.